FK Consulting and Agent Aid presents. Good day and welcome to this chapter regarding mandates. This section is extracted from the relevant regulation as mentioned in your booklet and corresponds with section 34.3. This section is applicable to estate agents specifically and all other sections that follow after. 4.1. No estate agent shall offer, purport, or attempt to offer any immovable property for sale, or to let or negotiate in connection therewith, or canvass or undertake or offer to canvass a purchaser or lessee therefore, unless he has been given a mandate to do so by the seller or lesser of the property or his duly authorized agent. On behalf of a prospective purchaser or lessee, offer, purport, or attempt to offer to purchase or lease any immovable property, or negotiate in connection therewith, or canvass, or undertake, or offer to canvass a seller or lessor therefore, unless he has been given a mandate to do so by such prospective purchaser or lessee, as the case may be, or his duly authorized agent. Except a sole mandate, or the extension of the period of an existing sole mandate, unless all the terms of such mandate or extension, as the case may be, are in writing and signed by the client in a manner acceptable in law, including by way of an electronic signature, as permitted under the Electronic Transactions and Communications Act, 2002. The expiry date of the mandate or extension, as the case may be, which shall be expressed as a calendar date, is specifically recorded in the written sole mandate or extension, as the case may be, except a sole mandate which contains a provision conferring upon him an option to extend the sole mandate for a certain period after expiry of the sole mandate, a mandate to continue to render the same service referred to in the sole mandate after expiry of the sole mandate, except a sole mandate which also confers upon him a power of attorney to act on behalf of the person conferring the mandate, unless the intention and effect of such power of attorney is fully explained in the document embodying the sole mandate. Include, or cause to be included, or accept the benefit of, any clause in a contract of sale or lease of immovable property negotiated by him, whereby a sole mandate is directly or indirectly conferred upon him to sell or let the said immovable property at any time after the conclusion of the said contract. Accept any mandate or instructions for work in respect of immovable property, if his interest therein would compete with his obligations towards an existing client in respect of the same immovable property, without first disclosing such interest in writing to such client. Knowingly or negligently make a material misrepresentation concerning the likely market value or rental income of immovable property to a seller or lessor thereof, in order to obtain a mandate in respect of such property. Accept a mandate in respect of any immovable property, if the performance of the mandate requires specialized skill or knowledge falling outside his field of competence, unless he will, in the performance of the mandate, be assisted by a person who has the required skill or knowledge, and this fact is disclosed in writing to the client. Accept a sole mandate to sell or let immovable property, unless he has explained in writing to the client the legal implications should the client, during the currency of the sole mandate or thereafter, sell or let the property without the assistance of the estate agent or through the intervention of another estate agent. What specific obligations in respect of the marketing of the property will be assumed by the estate agent in his endeavour to perform the mandate, provided that such explanations, if contained in a standard, pre-printed or typed sole mandate document, shall be in lettering, not smaller than that generally used in the remainder of the document. Important notes on this section. Property practitioners may not offer to or perform any estate agent duties without a mandate to do so. It is not a requirement to have the mandate in writing for open mandates, but it is difficult to prove consent given without it being in writing, so it is advised to have mandates in written format, even if it is just in the form of an email. This clause also deals with the right of privacy, and not to make misrepresentations to potential buyers. What types of mandates exist, and how are they defined? Open mandate. Multiple mandates are granted to more than one agent or agency, and the owner themselves may also sell the property privately, should they choose to do so. Two, sole mandate. A mandate is conferred to one agent, who is the only agent allowed to market and sell the property. But the owner may also sell the property privately, should they choose to do so. Three, exclusive sole mandate. A mandate is conferred to one agent who is the only agent allowed to market and sell the property, and the owner may not sell their property privately as long as the exclusive sole mandate is valid. Sole and exclusive mandates must be in writing. Sole mandates must contain the following specific details in order to be valid. One, must be in writing and signed by both the client and the agent. Electronic signatures are allowed if it complies with the Electronic Communications Act. Two, the expiry date of the mandate must be given as a calendar date and specifically recorded in the mandate document. Three, any liability conferred to the client if they decide to privately sell their property or make use of services of another property practitioner while the mandate is intact. For example, the possibility of having to pay double commission in certain circumstances. Four, the specific obligations in respect of marketing of the property that the property practitioner intends to use. For example, if they are going to make use of featured listings, how often feedback will be given, and a marketing plan document must be presented to the client. Sole mandates may not have an automatic extension clause. Sole mandates may only run for a specified time as per the mandate agreement and may not run perpetually or extend automatically when it expires. The duties and obligations as set out in the marketing plan must come to an end when the sole mandate expires. Sole mandates may be renewed if agreed upon in writing and if a new sole mandate agreement is signed with a new expiry date. Power of attorney clauses may not be added to a sole mandate unless the full extent of the power of attorney is detailed in the sole mandate agreement. Such a clause may not be added to a sole mandate agreement. Sale and lease agreements may not contain clauses giving a property practitioner a sole or exclusive mandate. Any mandate agreements are supposed to be a separate agreement, and therefore, no clauses talking about mandates may be included in a lease or sale agreement. All clients should be afforded the opportunity to make a free choice on which property practitioner they want to use, and any clause in any agreement which infringes on this choice is not permitted. Any conflicts of interest must be disclosed. If, for any reason, the property practitioner has a conflict of interest regarding any transaction, this conflict of interest must be disclosed in writing. For example, if the property practitioner themselves are going to be both the buyer and agent for the transaction, the seller must be informed of this fact. Property practitioners may not misrepresent the fair value of a property in order to obtain a mandate. For example, if a client believes their property is worth 4 million rand, and based on a thorough market analysis, the property is only worth 3.2 million rand, you may not tell the client you can sell the property for 4 million rand just so they will give you a mandate. Any value of a property given must be substantiated by evidence, either by market analysis or a certified valuation. Property practitioners may not offer services if they do not have the skill to do it. For example, you may not give a valuation on a property if you are not a qualified valuer. You can only give an estimated value based on a market analysis. A purchaser should be free at all times to select the estate agent of their choice should they want to resell or let the property. A developer may not restrict the purchaser to a future choice of estate agent. An understanding of double commission and the effective cause of the sale should be made clear to the seller. Property practitioners may not accept a sole mandate or exclusive mandate unless they have explained the legal implications should the client sell or let through another agent or privately in the case of an exclusive mandate. The commission implications after termination of the sole mandate to a person who was, however, introduced to the property by the sole agent during the currency of the mandate must also be explained to sellers. Property practitioners must present to the clients a specific marketing plan for their property. Estate agents must specify their obligations that will be assumed in the performance of the mandate. If this is not specified, it may constitute grounds for cancellation of the sole mandate. For example, if the estate agent plans on hosting show houses every weekend and are going to list the property using a featured listing, these obligations must be specified in the marketing plan. This online learning experience was delivered to you by ETD College. Thank you for attending, and we will see you in the next lesson.